Hello everybody, welcome to the ePathshala course on intellectual property rights. We are going to discuss the module on TRIPS agreement and its relationship with public health, also certain challenges dealing with access for medicines. The outline of this course is briefly summarized here. We will primarily discuss the nature of pharmaceutical industry and markets and what role intellectual property rights play in pharmaceutical innovation. We will also try and see why TRIPS agreement is important and the role of TRIPS agreement and the framework of developing countries or the role of developing countries in implementing the TRIPS agreement. We will discuss certain provisions on patents and public health. These primarily relate to the chapter in TRIPS agreement that has to deal with specific provisions on patent law that member countries are requested to implement. We will discuss the test and regulatory data protection that is required under Article 39.3 of the TRIPS agreement and what this protection actually entails. We will also discuss, taking into account the Indian context, the unique features of Indian law, both in terms of section 3D, which is one of the most controversial sections that is debated in the context of TRIPS implementation, and also India's recent grant of a compulsory license and the ground that is usually quoted as being controversial based on the ground of local working. Finally, we will conclude with a summary so that we summarize on the important points that are made in this course. So, if you understand the pharmaceutical industry, it is a high risk business model. The risk of failure is larger than the risk of success. So, 1 in 10,000 modules make it to the market finally. So, IP dependency in case of pharmaceutical innovation is largely affirmed through various market surveys by Taylor and Silberstein, Cohen, Mansfield and others who have done multi-stakeholder surveys to find out the importance or the relevance of patent protection in the pharmaceutical industry. So, this particular surveys affirm the role or the positive role of patents in case of pharmaceutical industry. However, the figures that are usually cited by the pharmaceutical industry have been rather controversial, and these have been regularly disputed by various civil society movements and also academics, saying that the investment figures are actually exaggerated by pharmaceutical companies. Pharmaceutical innovation is quite distinct from other forms of innovation in that pharmaceutical innovation is largely linear from the lowest common denominator of actually basic and applied research till it reaches the point of production and subsequent marketing. So, primarily one or few of those companies may be involved from the first point till the last point it reaches the end consumers. However, this may be different in case of software industry where innovation is both sequential and complementary. The average profits in pharmaceutical industry are much higher than the average profits in other industries. This has been confirmed by various magazines like the Forbes and others who have rated pharmaceutical industries as among the top profit making industries in the world. However, pharmaceutical industry faces higher governmental or regulatory control. So, such forms of control may be exercised through controlling prices or certain kind of reimbursement schemes, insurance companies and certain kind of limitations on marketing and promotion, or these restrictions are specifically invoked because pharmaceutical involve a lot of ethical drug marketing, or in situations where we know that the doctor chooses and the consumer pays. Pharmaceutical markets also are known to have less price competition. So, the highest selling brand may also be the most priced one, unlike in case of other products where due to competition people may choose lower price products. In case of pharmaceutical, the higher priced product may be preferred by consumers due to its unique nature. There is also some kind of huge controversy involving price discrimination by patent owners in developing countries, because the income levels between developed and developing countries are disparate. That's the reason why global price discrimination is something that people involving access to medicines have called for. However, pharmaceutical companies may be wary of price discrimination, barring minor exceptions. As I mentioned earlier, pharmaceutical markets are unique also because we deal with ethical drugs, in the sense that these drugs are usually prescribed by the doctors and consumers have very less choice in choosing them. There are certain innovation issues involving pharmaceutical industry. They primarily have to deal with the decline of new chemical entities innovation. There have been studies which show that there have been drastic decline in terms of pharmaceutical industries coming up with new chemical entities. The pharmaceutical landscape in terms of broader innovation is also changing from chemical based invention to new molecular invention involving biodrugs and biotechnology, where technology is the dominant driver. Certain cases of innovation involving neglected drugs and orphan drugs may also not be easily generated through the patent based system. So primarily neglected disease that have to deal with the developing or the least developed countries may not be produced by the pharmaceutical companies for want of better markets, and certain kinds of drugs that treat rare diseases may also not be produced by virtue of the patent system. So why TRIPS? If you look into the origins of the TRIPS agreement, the role of pharmaceutical industries in actually recommending the USTR to initiate dialogue on TRIPS during the Uruguay round is pretty much clear. So these companies were not just involved in lobbying with their respective governments, but they are also known to have lobbied with different industry organizations abroad, including the European Community and Japan, and then finally asking their support to see that the TRIPS agreement goes through the Uruguay round. So pharmaceutical companies naturally had a predominant role. But having said that, there was also kind of a perception that the Paris Convention was pretty much insufficient in providing international protection. So the Paris Convention, as you might have seen from the previous modules, basically had to deal with principles of national treatment, where a domestic inventor or a IP holder vis-a-vis a foreign IP holder is treated or provided same treatment, which finally becomes no less favorable treatment in case of TRIPS agreement. The priority period involving filing of intellectual property application is provided as 12 months, and the principle of independence of patents. It means a WTO member country or a Paris Union member country shall not deny patents primarily because any other country has denied protection. So basically you will have to deal with grant or denial based on the domestic laws and not by relying on other laws. That cannot be a reasonable ground for denying patents. However, TRIPS is Paris plus, in the sense that it goes far beyond the requirements of the Paris Convention, and naturally, because TRIPS agreement was trying to remedy the deficiency in the Paris Convention. Importantly, unlike the TRIPS agreement, which requires that legal effect must be given to the provisions of the TRIPS agreement, the Paris Convention did not say so in so many words. It means Paris Convention did not require member countries to come out with a patent law where they had none. So this is one of the important distinctions between Paris and TRIPS. However, in case of pharmaceuticals, it was a different game changer, because the patent provisions in the TRIPS agreement largely define what subject matter has to be protected or what subject matter can get excluded. TRIPS agreement also defines the rights, which were missing completely in the Paris Convention. It also defines the limited exceptions and certain conditions on use without authorization. The term of protection is specified in the TRIPS agreement. Also, the terms relating to revocation, however, no grounds have been specified on revocation. TRIPS agreement also requires that certain conditions have to be followed in case of, or may be followed in case of, disclosure requirement involving patents. However, TRIPS was important in the sense that TRIPS linked the provisions of its agreement with the dispute settlement mechanism, and hence any countries who does not implement the TRIPS agreement within its own legal system, that particular country can be taken to the WTO and the dispute settlement process can be invoked. Importantly, TRIPS agreement as a document also uses the language of balance. If you look into the preamble, which talks about balance between protection and enforcement, if you look into Article 7, which talks about balance of rights and obligation, if you look into Article 8, which allows public interest measures to be adopted by WTO member countries, we can fairly say that TRIPS allows certain kinds of flexibilities to be used by WTO member countries. At the same time, these flexibilities are sometimes explicit, as in case of a compulsory license which can be granted on any ground, or in case of certain limited exceptions that may be provided, and also sometimes these are non-explicit, where you can interpret certain provisions to provide you certain kind of a maneuvering space within your domestic policy context. TRIPS also allows countries to have freedom to determine the principles of exhaustion of intellectual property rights, either being national exhaustion or international exhaustion. TRIPS also has come out with what is called as August 2003 decision post the Doha Declaration on Public Health, wherein specifically a compulsory license meant for export purposes can be granted. It was primarily to avoid or to remedy the legal impediment created by the existing provisions of the TRIPS agreement, wherein a compulsory license could be granted only predominantly for the purpose of supply of the domestic market. So this kind of created legal barriers for export through a compulsory license, but it was finally remedied through the paragraph 6 mechanism and the August 2003 decision of the TRIPS agreement. There are different transition periods involving developing countries, developed countries and least developed countries. Primarily those countries which did not have a product patent regime at the time of signing of the TRIPS agreement were allowed a 10-year transition period. Furthermore, transition period for implementation of the TRIPS agreement for least developed countries has been extended to 2021, and hence the least developed countries need not implement the TRIPS agreement provided they provide national treatment and most favored nation treatment, and they also need not provide product patent for pharmaceuticals and agrochemicals. Finally, TRIPS agreement is not the all and end all of international intellectual property. Post TRIPS, there have been many attempts to ratchet up the international norm setting and standards relating to intellectual property protection through agreements like ACTA, anti-counterfeiting trade agreements, and certain other forms of plurilateral agreements like the TPP, Trans-Pacific Partnership Agreement, and also investment treaties or bilateral investment treaties. So a combination of these may lead to, and if countries are party to such treaties, it may lead to enhanced protection, international protection for intellectual property owners. So what are the provisions relating to patents in public health? TRIPS agreement does not define what a patent actually is. However, it is generally understood that it protects certain kinds of rights in relation to a new invention. TRIPS agreement, however, defines the patentability criteria in terms of novelty, inventive step, and industrial application. Again, these terms are not clearly defined. One of the first requirements under TRIPS agreement in Article 27.1, which deals with subject matter, is that patent shall be granted on any invention. What it means to be an invention is not defined under the law, under the TRIPS agreement, but it is generally understood as a new solution to a technical problem. So members may generally exclude inventions based on abstractness of the invention, or if the invention relates to a scientific theory or products of nature, etc., or mental steps, pure mental steps. These may be excluded, but there is ample controversy as to how invention is perceived and understood by different WTO member countries. Second, novelty is one of the important requirements under TRIPS agreement. Again, TRIPS does not define what standard of novelty should WTO member countries follow, whether novelty should be global or local, in the sense that if you judge prior art for the purposes of an invention, whether the prior art should be located within the territory of your country or whether it should be located internationally is not resolved by the TRIPS agreement. Furthermore, how these prior art has to be evaluated and what this prior art actually means has not been discussed. So it gives enough leeway for WTO member countries to actually look into different mechanisms to evaluate prior art. So in the context of patent law, novelty would mean that you are determining and trying to compare both prior publication and prior use in terms of the new invention and how the new invention actually reversely infringes on the existing pieces of publication or prior use. However, combination of prior art cannot be used generally as hitting novelty. The other criteria involving TRIPS agreement is the criteria of inventive step. Again, TRIPS agreement does not define how this criteria has to be understood and evaluated. Different countries have followed different mechanisms, and what you try and basically do in inventive step is to find out what are the steps taken by the inventor or the patent applicant to define the problem and to define the solution, and the steps taken from the problem and how the solution has been achieved. So these steps in themselves must be inventive. So basically inventive step has to generally deal with steps taken to reach a problem, from a problem to a solution. Primarily they involve technical advance. Secondarily, they may involve other circumstances like commercial success of the product. In a recent case, in a case involving KSR versus Teleflex decided by the United States Supreme Court, it is pretty much clear that WTO member countries have certain leeway or policy space to maneuver around the degree of inventive step that may be required. Finally, industrial application or usefulness or the criteria of utility again remains undefined, but as generally understood by WTO member countries, this does not require commercial utility per se. However, the particular product or a process must have some kind of industrial application, in the sense that it can be applied in any particular industry, including agriculture. Now, this one of those cases, early cases decided in the UK, wherein an invention that related to perpetual motion machine was rejected by the patent office for lack of utility or industrial application, because this perpetual motion machine and the idea of it ran contrary to the principles of thermodynamics.